Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick, and Bruno. We've got three questions today. We're going to jump straight into the first one with yourself, Bruno. This one is just regarding, obviously, estate planning. So what we have, guys, we've got basically a situation where an individual basically owns properties and shares. They now want to begin the journey of estate planning around their portfolio, but they've got quite a very common question that we always receive, which is regarding costs, and that is what are basically some of the costs to look at when one is basically moving properties and shares into other trusts and companies. Bruno?
So estate planning is crucial, especially when it comes to property investors or any kind of property owner. And I say this repetitively because the value of the property is always quite high. So your estate planning becomes difficult if you later on try and move assets from different structures when you should have initially been doing it. So estate planning needs to be something that you do from the onset. But occasionally we do find clients that approach us after the fact to say that they'd bought properties, say in a company, or bought it in their personal names, and now they're looking to move these properties across into some sort of estate planning structure that they've created for themselves. Now, these estate planning structures you often find in the property space. It is very common and very popular to have structures that include some form of trust, South African trust, and this especially for South African residents, where trust is a great estate planning vehicle. Now, to move, the first thing that a person needs to bear in mind is that a trust is basically a different person, a separate individual altogether. So you moving things over into a trust structure, and when I say structure, I mean a structure that at least has the trust at the top, whichever way the rest of the structure appears, there is at least a trust somewhere in that structure. So trying to move it into that structure is almost like giving your property away to another individual. Now, yes, because the trust is founded by you, because you're a trustee of a trust, and because it's your beneficiaries that are benefiting from the trust, sure, you've got a level of control on how the proceeds or how the benefits are to be distributed, but make no mistake, this trust is not supposed to be your alter ego. In fact, if it is your alter ego, the trust will be dissolved by a court, or as they call it, pierce the corporate veil, which basically means that the courts will ignore that the trust even exists. So it has to be administered properly, it has to be run properly for the benefit of the beneficiaries, not just yourself. So insofar as costs are concerned, and we can keep discussing this if there are questions around this, please let me have your questions and we can answer it week by week. But in short, because you're transferring your assets to a completely new vehicle, new person, new entity, you have to almost treat it like you're the same way that you'd sell it to anyone else. And this carries consequences. And these consequences, if it's a trust structure, mind you, these consequences obviously are an accumulation of taxes and costs. If you're moving a property, normally the same amount that you've paid to have the property transferred into your name will be the amount that you now be liable for. The transfer duty, same thing. If you were liable to pay transfer duty, it's very likely that you'd have to pay transfer duty again in order to move the property into this investment structure. Capital gains tax is also another big one. If you acquired the property for a relatively low amount and now it carries a very high value, there might be a tax component between these two values that have to be paid. And finally, if within your trust structure, you're actually applying for a bond in order to be able to finance the purchase of this property, remember, donating a property is probably going to cost you a lot more when it comes to tax. So typically people try to finance a sale where they buy it into the investment structure, but there is a bond over it, and then there's normally bond registration fees, because again, it's a new person, so it's a new bond. Now, there are ways to work around some of these costs, to reduce these costs, to mitigate, and all legitimate. It just takes some calculations. But this is the overview at a high level on what one could anticipate paying when doing what we call an asset transfer.
Yeah. So yeah, thank you very much there, Bruno. Certainly much valuable information. We'll be delving obviously much deeper into estate planning and trust and companies, as obviously this structuring forms a very important part when one actually does invest in property as a professional. Right. Thank you very much. And then what we'll do, okay, we're jumping into the first, the second question with yourself, Nick. So this one goes as follows. We have a tenant. So this one comes from an agent. They have a tenant that wants to provide her 20 business days notice and is also accepting responsibility for the cancellation penalty. However, the tenant does not want to be held liable for the 3-month period should we not place a new tenant due to the nature of her being forced to cancel the lease. Her being forced is because she states that there is an unwanted and destructive spiritual presence in the home, which is causing extreme discomfort and fear for the tenant. The landlord is, of course, now in denial of this presence, of this destructive spiritual presence, and hasn't assisted in any way to have it removed. So the tenant is claiming it's not their fault. Nothing has been done despite it being reported. The question then, can we still enforce the rental bills in this case should the house not be rented out timelessly? Also, this being said, this is a he said, she said situation. So, will this have to be disclosed to the new potential tenants? And I suppose that is referring to the spirits that are being destructive. Nick, you might have to break that down into a couple of sections,
Yeah.
but yeah.
Perfect. Okay, so let's just deal with the starting point of this is there's been a 20 business days notice to cancel the agreement. And it said that the tenant accepts the cancellation penalty. So this obviously refers to our Section 14 of the Consumer Protection Act. Section 14 provides that a consumer of a service is entitled to cancel a fixed term agreement with a 20 business day notice to the supplier of that particular service, and that includes lease agreements within our society. Okay, so the consumer, the tenant in the circumstances, is entitled to give a 20 business day notice to cancel the agreement. Now, what is important about that 20 business day notice is it is not a cancellation of an agreement where a breach is necessary, okay, as is formally, most contracts within our society, they function, and the cancellation occurs if there's a breach. Some party is not performing in terms of the contract as they should be. That is not the case. The Consumer Protection Act provides this out for a consumer of a particular service, just as a means of protection for them. Okay, so there doesn't have to be a reason, okay, for this cancellation. The tenant can do it at any point, and whether they just want to get out of the contract or they believe that something is happening on the premises that they don't like, that doesn't matter. They have this right. The kicker to that right is that they can be liable for a reasonable cancellation penalty. We're told that the tenant accepts the reasonable cancellation penalty in the circumstances, and the landlord can enforce that. Okay, what that reasonable cancellation penalty is depends on the facts of the particular case, okay, and the circumstances of the particular case. Where I want to be careful about this particular question is I'm not sure if this is a provision that's written into the lease agreement about continue to pay rental. But rental is something very specific within our law that is remuneration for the use and enjoyment of someone else's property. Okay, that is all rental is. And if a lease agreement comes to an end, okay, so it's cancelled, you are no longer entitled rental from the cancellation of that agreement, okay, because you're not entitled to the use and enjoyment of the premises once the lease agreement comes to an end, okay. So I've got a little bit of question about how the question was actually phrased. Okay, so you wouldn't be entitled rental from the point of cancellation. So I'm not sure if this is a hang up from the particular wording of this lease agreement. You would then at that point be liable for the cancellation penalty. And that is all you'd be entitled to. You can't have a situation where you're getting rental after the cancellation of the lease agreement, plus also you get a cancellation penalty on top of it, even if your lease agreement said that. That's going to fly in the face of legislation, so that might be a problem. So just to the question there, I would need a bit more clarity on that circumstance, but it doesn't seem like your first question was, can you continue to enforce the rental? No, not if the tenant has given a cancellation, and the reason for that cancellation is irrespective of what they say. And then to your second question, do you have to disclose this to any incoming tenants on the particular property? No. There's no positive obligation on landlords really to disclose anything with regards to the property, apart from the fact that the Rental Housing Act does have some entry inspection requirements which you must comply with when you are taking a tenant into the property. But no, there's no need to disclose something like this to any incoming tenant in the future.
So Nick, on that point, I actually remember at a stage we did a video. I think Silna and I did a video like this. I think in that instance there was a death on the property, some time back.
Yes.
So there was also again like a spiritual issue where this person had found out that there was a death, and so obviously their complaint to the landlord was that they should have been told about this, or that any crime was committed on the property, even if it wasn't a death. So obviously it's always a difficult one because materiality really depends on the individual. So for some people it'll be like, oh well, you know, it doesn't impact me, so does it really matter? And obviously for other people it's more material. But what we have found in practice, and this goes to exactly what Nick was saying, is these in practice, it's the condition of the property that's really catered for in our law, not these type of disclosures. I'm not saying that it's right or wrong. This isn't any sort of commentary on you know, the way things are approached, but the main focus is the property habitable? Is it in a good condition? And in those circumstances, it's normally accepted that anyone that moves into the property would have the use and enjoyment of the property the way that they intended. Yeah, so that just goes back to what you were saying, is this question comes up a lot more than one thinks. The landlord does have an obligation to disclose the condition of the property, no question. But things like this, yeah, it's not a must.
Yeah.
Right. So yeah, thank you very much, then, Nick, and obviously thank you to yourself as well, Bruno, for chipping in. And then second question, which is the last question for today. Nick, this one much shorter. It says we have a situation now where a joint incoming inspection was not done, right, or which was not signed by the tenant. As I understand it, this is the viewer. As I understand it, no damages may therefore be deducted from the tenant's deposit, and the full deposit must be refunded. The question here is that the tenant is also now in areas with the actual monthly rental. Now, the actual question, may we deduct the area, may we deduct the area rental from his deposit? Or is it a case of because no incoming inspection was done, we're not allowed to deduct anything from the deposit? Nick?
Okay, so we'll first talk about deposits. Deposits are a very normal practice that occurs throughout leasing. Okay, it's one of the means of security that a landlord is entitled to use in order to secure non-payment or from the tenants in terms of their contracts. Okay, deposits, there are other forms of security that are used, but the deposit is the most common. Anyone who's entered into a lease probably has run into this experience. And so the deposit is a means of security that the landlord has to ensure that it can cover any costs that it might experience later down the road. Okay. Now, although there are a number of provisions that are set out within the Rental Housing Act with regards to incoming inspections, exit inspections, and what exactly you need to do on the part of the landlord when you are entering into a lease agreement. Okay, the deposit is not only a security for the damage that's done to the premises. The deposit is security for anything that may be payable by the tenant to the landlord in terms of the lease agreement. So that does include damage which is resulted from the tenant staying in the premises, and damage which may be found out as a result of outgoing, ingoing inspections. Okay, so it can cover that, but the deposit can just as readily cover your arrear rental that hasn't been paid, your utilities that hasn't been paid, or whatever other charges that might be levied onto the particular property, as long as you've included it within your lease agreement. So there is obviously, what they've indicated is there may be a problem with regards to the ingoing and outgoing inspections on the property. I don't want to specifically comment because I don't know the factual details of what exactly happened there and where they might or might not fall shy of legislation. And that's something I can't really comment on without having looked at the facts. But what the question is from the writer is, if there is, let's assume that there is a problem with the ingoing or outgoing inspections of the particular property, does that mean now that we're precluded from using the deposit for other amounts which might be outstanding? Okay. And the answer to that is no. Okay. If there is a problem with the ingoing, outgoing inspections, there are provisions within the Rental Housing Act which deem that the property is in a good condition when it is handed back. Okay, so it's very important for landlords to make sure they're up to date with that legislation, and they know that they need to do ingoing and outgoing inspections, because you will have a deeming provision that says that the property is in good condition if you haven't fulfilled the conditions of the Rental Housing Act. But that in of itself does not mean that the deposit is completely protected from use. And in particular, if there are other amounts outstanding, they haven't paid their rental, they haven't paid the utilities on your monthly statements, the deposit can still be used for those particular charges. And if they've been satisfied, and then there is a portion which is left over, that portion might be protected by virtue of the act, and it might have to be paid back to the tenant in the circumstances. But certainly, just because there might be a problem with regard to inspections does not mean that your deposit can't be used for your arrear amounts in terms of the lease agreement period.
So yeah, thank you very much, then, Nick. That does bring us to the end of today's episode, ladies and gentlemen. Thank you to the agents, the viewers, and for everybody else to keeping the questions coming. And yeah, we'll see everybody again next week. Thank you very much.
Thanks, guys. Cheers.
Thanks, cheers.